You're watching The Legal Breakdown. So, Glenn, I want to dig into a signal that the prosecutors have sent in the New York criminal trial against Trump that pretty much shows that they've got this thing in the bag. So we're going to dig into that. But first, just a reminder for everybody watching right now, if you want to follow along with Glenn and I as we continue with our daily comprehensive coverage of this trial, please make sure to subscribe. Okay, Glenn, can you speak about what the prosecutors did in this case that pretty much signals that they're in really good shape as we head toward the end here?
Yeah, Brian, a little bit of prosecutorial inside baseball. I was surprised when I heard that Michael Cohen will be the last prosecution witness. That actually speaks volumes about how the prosecution team believes Michael Cohen is performing on the witness stand. You know, criminal litigators, prosecutors, and defense attorneys have this rule that we follow: primacy, recency. Start strong, finish strong. It's really important to finish strong when you are resting your case before the jury. Usually what you want to do is put on a blockbuster witness to be your final witness, so you leave the jury with the story that, you know, this case is strong, the evidence has proved guilt beyond a reasonable doubt. So I didn't think they were going to end with Michael Cohen, but we learned late yesterday at the close of the trial date that they are not going to call any other witnesses. So now Michael Cohen, who is still on the stand, he's about midway through cross-examination. He has not only been holding his own during cross-examination by Todd Blanche, Donald Trump's lead criminal defense attorney, but people need to remember, after he is done being cross-examined by Todd Blanche, the prosecutors get the last word. We get what's called redirect examination. And what we do is we go back and we clean up any answers that Michael Cohen gave that we think were less than optimal or were perhaps incomplete, because on cross-examination, the whole goal is to box a witness in to answering a question yes or no. You don't get to explain. That's not for cross-examination. Yeah, but it is for redirect examination. And that's when I will go to my witness and say, you know what, Mr. Cohen, the defense attorney, didn't let you explain, which is his right on cross-examination, but would you like to explain something about that answer you gave, that was no or yes to a particular question? And that is when the explanation comes tumbling out. And that's usually when the jury will kind of turn to the defense and be like, well, you were clearly only providing us with half of the story when you were not letting the witness explain his answer. So I think it's a sign that the prosecutors, don't necessarily believe they have a sure winner, but they believe Michael Cohen's testimony has done real damage to Donald Trump, so much so that they want to end with his testimony.
Well, kind of adding insult to injury here, does the fact that not only the prosecutors seeing that their case is pretty much in the bag or is going as well as they could hope that it could go for, to the point where they're not even calling any other witnesses, is the fact that the defense now is signaling that they're not going to be calling anybody. Does that kind of add insult to injury here?
I think it's telling that the, defense team for Donald Trump can't find a single witness to come in and exonerate Donald Trump, prop him up, knock down Stormy Daniels or Michael Cohen or David Pecker or Hope Hicks or Keith Davidson or any of the other witnesses. They have nothing? Are you kidding me? Well, that is often the way of criminal defenses. Why? Because when the evidence is strong, indeed conclusive, the defense is left with nothing. If you put on, as a defense attorney, a couple of kind of half-assed witnesses who really don't provide anything blockbuster, you know the signal you're sending to the jury? We got nothing. So here's why they decide to actually present nothing instead of a couple of half-baked witnesses who really don't have much to offer the jury. Here's what they're going to say in closing argument. I can all but guarantee it. They're going to say, ladies and gentlemen, you might have noticed we didn't call any witnesses. We didn't, feel the need to call our client Donald Trump to the stand to testify. We didn't introduce any documents, any records, any evidence. You know why? Because the government so miserably failed in meeting its burden of proof beyond a reasonable doubt. And as we watched their case crumble, we made the decision we don't have to call any witnesses because they have the burden of proof. We don't. The burden never shifts to us, and they failed to prove to your satisfaction that Donald Trump committed crimes beyond a reasonable doubt. Now, go back into that deliberation room and do the right thing and send my client home. I've heard some variation of that countless times in courtrooms, and what I knew was that they had nothing. They had no solid witnesses to present, so they were hanging their hat on the burden of proof, reasonable beyond a reasonable doubt.
Glenn, given the fact that we may just see this final redirect where prosecutors get one more bite at the apple, that is speaking with Michael Cohen on the stand, if Trump's defense team opts not to call anybody, what are next steps here? Because we could be looking at the end of this thing pretty quickly.
Yeah, so next steps. Once the government has announced that they've called their final witness and they rest their case in chief, then the judge will turn to the defense and say, do you have any witnesses to call or evidence to present? If Donald Trump's lawyers say, no, we're not presenting anything, then there's going to be some time that the parties and the judge will take out of the presence of the jury to go through the legal instructions, the instructions of law that the parties will want the judge to give to the jury. The instructions of law help frame and channel the jurors' deliberations so they know precisely what they need to find if they're going to convict the defendant of any of the counts of the indictment. And then they'll go to closing arguments. Usually the judge will give people a half a day or maybe a full day to just kind of prepare and fine-tune their closing arguments. And then we could see closing arguments as early as maybe Monday morning. And then by Tuesday, Brian, this case could be in the hands of the jury. Nobody can predict how long a jury will deliberate. I've had juries deliberate 45 minutes in a 2-week murder trial. I've had them deliberate for well over a month in a longer, more complex RICO trial. But you never know how long a jury is going to take to decide this case. And they have heard lots of evidence, not just lots of witnesses, but they've seen lots of documentary evidence. They've seen text messages and phone records. They've seen ledger entries and bogus checks written by Donald Trump, fraudulent checks, disguised as payment for legal services that were really to reimburse Michael Cohen for the hush money payments he made to Stormy Daniels. So they're going to have a lot of evidence to pour through, so they could actually have it several days before, they move in the direction of reaching verdicts.
And of course, if they land on not guilty, that's that. If they land on guilty, what are next steps? And can you talk about sentencing and who decides what the sentence is going to be?
Yeah, so next steps will be there will be a pre-sentence report generated that is a pretty lengthy document that is assembled by an agency of the court, basically a pre-sentence report writer, and it's designed to provide a whole bunch of information to the judge about the offenses, about the victims, about the defendant and, his history, his criminal history, his educational history, his background, and it gives the judge as much information about the offenses and the offender so that the judge will be fully informed and fully equipped to impose the most appropriate sentence. For each conviction, there are 34 felony counts of falsifying business records. Each one carries up to 4 years in prison. However, each one is also probation eligible. What does that mean? That means even if Donald Trump were convicted of all 34 counts, he could still walk away with probation, no jail time. I don't suspect that's what's going to happen because I think Judge Merchan will understand that if he does not provide some kind of punishment to Donald Trump by way of a jail term, then he is not deterring this conduct in the future. He's not deterring it in Donald Trump, which is called specific deterrence, and he's not deterring it in others, which is called general deterrence. So I think the smarter money will be riding on a potential jail term in the event Donald Trump is convicted. Okay, well, obviously a lot to happen here, but we may see some type of resolution. We may see some type of sentencing as early as just a couple of weeks from now, and we may certainly see a conviction verdict from the jury within less than a week here. So for those watching right now, if you want to follow along as we continue to cover the entirety of this trial, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen. And I'm Glenn Kirshner.
You're watching The Legal Breakdown.